Commonwealth versus Peterson.
Ms. Eisenberg.
Good morning. I guess I will pick up where the parties left off in this case before mine. The principal issue that brings this case before the court on direct appellate review is the question of whether the trial court's failure to obtain in writing the defendant's waiver of his right to indictment invalidated the waiver and deprived the court of jurisdiction to try the defendant for the crimes. We also argue the no less important point of the defendant's Miranda rights having been violated, but with the court's permission, I think I'll first address the waiver issue.
Well, let's talk about the differences between this case and the prior case. First of all, the statute doesn't require that a waiver be in writing.
That's right. That is true. It is the rule that's promulgated by this court that requires that the writing shall be made.
And it certainly seems to me, upon a reading of the rule, that the rule doesn't specifically or wasn't specifically intended to cover this fairly unique circumstance here.
This is a unique circumstance, and I think that this rule, as in all rules, as Rule 2 indicates, which governs the spirit and the purpose that animates all of the criminal rules, is that the rules need to be interpreted in comportment with flexible notions of due process. So
how is the purpose of the rule undermined by what happened in this case here? The defendant was indicted. Just prior to trial, both the government and the defense counsel realized that something was missing. It could have gone back for re-indictment. It could have even been amended if there was no objection, could have gone forward. But they determined to simply null across the indictments, issue complaints with the additional wording, and proceed to trial. Both parties agreed to it. I mean, how is the purpose of the rule undermined by that kind of course of conduct?
Well, the purpose of the rule is to assure that the defendant knows what he is doing. There are three parts, I think, to – I mean, I guess if you're asking me how can you say that the defendant wasn't afforded the right to indictment here, he had the right to indictment, so how does the rule amplify?
And he waived it, and the judge had a colloquy. The defendant understood exactly what he was doing, and this was an efficient way of trying to move the case forward. There had been an indictment. There was no challenge to the adequacy of the evidence to support.
Well, the right to indictment has two parts. I mean, there's the concurrence of the 12 grand jurors for issuance of the true bill, and then you also have the right to know what you're defending against as alleged in the bill of indictment. So you have to have a bill of indictment that alleges all the essential elements of the offense. Now, here, just as the Commonwealth can represent evidence to a second grand jury if a first no bill, the defendant can certainly rightfully be of the view that just because one grand jury handed up a true bill doesn't mean that another grand jury would do the same. He's entitled to both parts of the process. He's entitled to both a written waiver, which assures the court that he knowingly has waived this important, substantive, personal right. This is not a right in the manner of the right that's discussed in Collado. The Collado issue deals with an aspect of the jury waiver statute and rule that the court explicitly says doesn't imply substantive personal rights. The right to indictment is substantive and personal. It is given rise to by the privileges and immunities of liberty. And this Court has recognized over and over again that that is a substantive personal right. So his waiver to that right under Rule 3 doesn't constitute a purely procedural waiver of a constitutional right. It's black-letter law that the difference between a procedural waiver of a claim as opposed to an express relinquishment of a substantive constitutional right is that the relinquishment of the substantive constitutional right be knowing and voluntary.
But didn't the judge satisfy himself as to that fact?
Well, but I think there are three pieces. The judge did a colloquy, and we haven't argued that the colloquy was inadequate. The judge told the defendant, in fact, that 13 grand jurors had to agree, but certainly the colloquy was not inadequate. But the judge's colloquy is only a part of the process. The other part of there are two other parts. One is the defendant commits his hand to a writing and says, I give this up. I understand the gravity of what I do. I understand the importance of what I do, I understand the finality of what I do, and I give it up.
Well,
And the second-
you say that's enlightening. I would say that comes when a judge questions somebody. I can't think of the number of times when I've signed my name to something, and I haven't. The signature is not the place where I can determine that I really knew what I was giving up. You know, I mean, who knows what he was being asked to sign that day? That's why I think we have colloquies, because the mere writing is not sufficient to determine that it's
I
an
agree.
express relinquishment. It's knowing, it's voluntary. You understand the import.
I agree. I think that it's not one or the other. I do think it is both, because I think what the colloquy does is it satisfies the judge that the defendant knows what he does. I think what the writing does is it betokens that the defendant understands the gravity and finality of what he does. And because the right is so important, because the right is so basic, this Court has seen fit to require to draft mandatory language, which is at its strongest when substantive rights are involved, to require that those pieces be executed together. And there's a third piece, which is that it also puts the prosecutor on notice and it provides the prosecutor with the opportunity to consent to doing away with their obligation to have to present the matter to the grand jury. I mean, the rule and the reporter notes make it clear that the prosecutor, that the judge doesn't have to approve the waiver, but the judge has to satisfy himself or herself that the waiver is voluntary and knowing and intelligent. But there does have to be consent by the prosecutor, and the reason for that is because the right is so fundamental. Now, this issue in this case is completely different from the derivative administrative provisions in Collado, and Collado should not govern the outcome of this case, and that's true for 4 reasons. Collado did not address the necessity of a writing. There is a bright-line rule here. I suggest to the Court that even though, as Justice Graney suggested, that in other statutes the legislature has provided for a remedy, there is stare decisis here. There is a large body of authority in which this Court and the appeals court have repeatedly said, I think it was Justice Freed who said, maybe it was in Pavao, I can't remember, but, you know, even if there's an almost irresistible proof in the record that there was a knowing waiver, the process has to be followed. And if the process isn't followed, then it's a nullity that the rule exists at all. And if the rule exists only to be implemented some of the time and not all of the time, then you get into problems involving due process and equal protection of defendants who are otherwise similarly situated. So there's a bright line rule here.
You lost me there. On the equal protection and on the due process.
Well, all I'm saying is that
I was with you until then,
okay.
but
all right,
you lost me on the last bit.
All right. All I'm saying is that what's true for one defendant must be true for all defendants if there's a mandatory rule. So in other words, some courts can't, by their own fiat, decide, I'm going to dispense with the writing. And in fact, in this case, when I sought the writing to see if there was a writing, because it wasn't really clear, I was told anecdotally that the Court never gets writings for these kinds of situations. And there was not a writing, but I went out to the clerk's office anyway to satisfy myself that there was not a writing. It's not a mere technicality. We also don't argue here, although the Commonwealth fixed on this point in its brief, that the defendant was entitled to a probable cause hearing. He's not in the district court. What we say is he's entitled either to an indictment or to waive the right to indictment. The second point with respect to Collado is that Collado held that voluntariness considerations of waiver don't apply to the all-or-nothing provisions of Rule 19, and it didn't confer any substantive personal right in the defendant. This Court has guaranteed by Rule 3 that indictment waiver provisions do vest personal rights in the criminal defendant, and they are designed for people who are in Mr. Peterson's position. And finally, I think Collado didn't involve the kind of error which arguably divests the trial court of jurisdiction. And, you know, in my brief, I initially argued otherwise, because the question was left open in the Perry P. case whether or not the failure to get an adequate waiver, what happens in terms of what the law requires with respect to double jeopardy considerations. And I think probably I was in error in my brief. I think the Superior Court here was divested of jurisdiction over the defendant when it accepted a defective waiver. And the reason that we say this is because
how do you just say that again? The Superior Court?
Yes, because we say that because there was no indictment and because the waiver was defective, the court had no jurisdiction to try the offense. And the reason that we say this is because it is a tenet of the state constitution, and in Commonwealth versus Wilcox, this court held that a defendant charged with an offense punishable by imprisonment in the state prison has the right to be proceeded against by indictment except when there's concurrent jurisdiction in the district court or if there's an adequate waiver. The nature of the crimes is what establishes the jurisdiction of the Superior Court. And so we say that the inquiry has to be framed, as this Court said recently, even in Commonwealth versus Oswald Smith, although that was in the context of the DNA statute. But this Court recently said that the inquiry is framed as whether the offense is punishable by state prison, not whether the defendant is actually punished to state prison. So if the waiver is defective and there's no legitimate indictment that precedes the trial of the defendant, then we say the court does not have the power to hear the case. And the trial was a nullity, which was one of the propositions that was discussed by the court in Perry P.
But it sometimes happens that during the course of an investigation, negotiations are had between the defense and the DA's office. I'm talking about an investigation of a crime that's only punishable by state prison, that they come to an agreement early on as to exactly what the outcome is going to be on a plea. And the district attorney will proceed, the district attorney, with the consent of the defendant, agrees to proceed by a DA's complaint. And they waive indictment and the complaint is issued. And sometimes the plea actually takes place the same day.
You don't have a problem with that. You're just saying that without a written waiver, it's not effective.
In the Superior Court.
I guess I'm sorry, I don't
You're saying
understand
that the Superior Court does not have jurisdiction over a case that is only prosecutable in the Superior Court.
Where the waiver is defective.
Unless there is a written waiver.
Right, unless the
But there's no rule that requires a written waiver in those circumstances.
Well,
where the case goes directly to the Superior Court.
Well, right. There are all sorts of outcomes that could. There's a rule that requires a written waiver in the Superior Court if the defendant is not indicted. What the outcome of the case is thereafter, I suppose, could take any number of forms.
But what rule is that? What rule requires a written waiver?
Rule 3, Rule 3D, requires the waiver to be in writing if the defendant is not indicted. If the defendant waives indictment, that waiver must be in writing.
I see what you're saying. Okay.
And so what I'm saying is if there's no indictment and there's no adequate waiver, then the court had no jurisdiction. So in this case, a substantial risk of a miscarriage of justice couldn't be the standard of review because you can't apply that standard of review.
Well, I think, I mean, as you heard from my discussion earlier, I don't think that that's the prism through which we look at it, but unfortunately, you know, all of the arguments in both cases, it violates the rule, yes, and what are the consequences?
Well, we say the consequences are.
I know, I understand you say that, but the reasoning and the I mean, I understand it's personal, I understand it's not Collado, it's problematic here because you've got a colloquy that you don't contest as defective.
The colloquy we don't contest is defective, right. I want to say one word about the Miranda issue, if I might. In particular, we want to stress 2 points. One is that without evidence of the confession, the Commonwealth's evidence at trial probably would not have survived required finding. It was extraordinarily feeble. And second, as to the interrogation itself, we want to stress the aggressive nature of the interrogation. The judge found the officer was courteous and even-tempered, but the cases that we've cited in our brief at pages 36 to 39 make it clear that tone of voice is not what is determinative. It is the aggressiveness and the exhaustiveness of the interrogation itself.
Thank you, Mr.
Thank you.
Mr. Peterson?
Good morning, Your Honors. And please the Court, Joseph Puropan for the Commonwealth. It is the Commonwealth's position that the defendant had the benefit of a grand jury proceeding, that he did not choose to contest the sufficiency of the probable cause in the grand jury, that in fact the defendant on his own initiative, as the colloquy shows, not only consented to but suggested that a district attorney's complaint be brought in lieu of the facially deficient indictments that the grand jury had been returned and which had been on file in the Superior Court for nearly a year. The grand jury met in this matter in May of 2001. The district attorney's complaints in the trial immediately thereafter were in May of 2002. And as counsel abundantly made clear in the colloquy, I believe at page 9, this is an informed decision by counsel and the defendant to simply rectify what could best be described as an omission of several.
Mr. Peterson, if we hold today in connection with either of these cases, first of all, I think the miscarriage, substantial risk of a miscarriage of justice is just barking up the wrong tree, right? Because there has to be a finding that it's knowing voluntarily, it's a personal right, it's an important right, and so on and so forth. And unless you show that, I don't care whether or not there is or isn't a substantial risk of a miscarriage of justice. That isn't the standard. I mean, I'm pretty clear about that. But assuming that there's a showing, and the defendant here says no problem with the colloquy here, unlike the case that preceded this, if we issue a ruling saying as long as you establish that, aren't we simply inviting, not willfully, but just pay no attention to the rule, pay no attention to the statute. You don't have to get it in writing. As long as you have the colloquy, that's fine. Just make sure you have the colloquy.
No, I respectfully disagree with
Why?
that, Your Honor. Well, for two reasons. Number one, this is a rather hybrid circumstance. This is not in a situation in which the defendant has been charged in the district court and either elects to waive indictment and proceed upon a probable cause hearing, at which point in time the complaint itself, the piece of paper in the district court, be transferred to the Superior Court. At that point in time, the rule is clear that a written waiver would be necessary. Parenthetically, the rule itself does require a written waiver, and I do not back down from that. I acknowledge that. This is a situation in which the defendant has already had the benefit of waiving all rights to challenge the complaint in the district court, elected neither a probable cause hearing, nor waived his right to indictment, but simply awaited the indictment by the district attorney in the grand jury. And at that point in time, on the eve of trial, rather than send the matter back to the grand jury or to the district court, said, consistent with the rules, I want my trial. I will waive grand jury. I will waive my right to indictment. I will simply accept this amendment of the indictment, which in essence is what the district attorney's complaint did. So I don't foresee in this particular circumstance, Your Honor, a rule going forth suggesting that these requirements can be waived. Bad choice of words. Can be overlooked. So I do not see that.
It need not be in writing, even though in one case the statute and the rule require it, and in another case the rule requires it. I mean, essentially, I hear the argument, but essentially it doesn't matter if you don't comply with the rules.
Well,
Because
no,
there's no consequence.
Well, no, I disagree with that, too, because in Collado, which I would say is in a posture similar to this one, there was an unintentional violation of the rule.
Collado, what the court is making very clear is that, I can get you the language, but it's not procedural, but this is not a personal right of the defendant. This is how one is going to conduct a trial. You do it all waive, none waive it, or you sever. You don't, it doesn't become the basis of severance, but you can't do it the way that it was done there. And it's really, if you read the Collado decision, which I think Justice Abrams wrote, it was really focused on sort of administrative, procedural matters.
And, Your Honor, I would respectfully suggest that in these circumstances, these are procedural matters, because the defendant was indicted. This is not a complaint brought out of thin air on a piece of paper of a crime for which the defendant had no notice.
Right. I understand.
If for some reason the indictments had been nolle prossed here before the DA's complaint had issued, do you agree that there should have been that there would have to have been a written waiver?
I would say, Your Honor, the better practice is to put things in writing. I would say, Your Honor, that if the district attorney had now processed the two attempt to burn a building indictments, if they then wish to resurrect those indictments by way of a district attorney's complaint, in these circumstances, I would say the same result would hold in that with counsel, again, if counsel and the defendant acknowledge that the grand jury heard sufficient evidence to indict for that crime, the return to the grand jury would be duplicitous and not necessary. I'm sorry.
Did you finish your answer to Judge Spina?
Because
I want you to.
Let me just say that I think I was simply going to add that I'll stop right there, Your Honor.
Okay.
Go ahead.
Well, my question is this. What is the significance of the language in Mass Rules of Criminal Procedure, Rule 3, the sentence, the waiver shall be in writing and filed in the Superior Court?
Mm-hmm.
If there is no writing.
If I may, Your Honor. And unfortunately, I don't wish to be critical of the rules of procedure or of the statutes, but those rules, I firmly believe, address primarily in complaints initiated in the district court that are transferred via bindover or probable cause hearing to the Superior Court, at which point in time the writing is required in the district court to be transferred.
Well, Section D says waiver of indictment in Superior Court.
Yes, that's the old rule, Your Honor, which is the rule we're working underneath here.
Right.
So yeah.
What do the words mean?
Well, the words mean this. The reporter's notes say that 3D pertains to the situation in which the defendant, having been bound over, changes his mind and wishes to waive indictment. So in that circumstance, yes, while the case is in flux, there would need to be an affirmative waiver by the defendant, signifying his wish to simply proceed upon the complaint that originated in the district court. Here, by contrast, we've already had the indictment. We've had a probable cause determination by the grand jury. We've had a written piece of paper filed with the court, which was not objected to by the defendant, and an attempt was made to rectify a error in language, not in substance, I would suggest, but an error in language, because the defendant acknowledged on the record that there was sufficient probable cause in the grand jury.
Why, just a question. Why didn't this case proceed simply by the indictment being amended by agreement? Was that procedurally appropriate to amend the indictment by agreement?
Unfortunately, Your Honor, I asked the same question of trial counsel, and the answer was it was agreed upon to bring the DA's complaints, which I don't think helps you answer the question, but that's the
just the way it was. All right.
I take it, and maybe I'm missing something entirely, but I take it from your understanding of the rule that essentially your interpretation of the rule is that this is not only to make sure that there's an indictment in writing, but it's somehow to give meaning to the right to have the grand jury find sufficient facts for an indictment to issue. In other words, if you start with a complaint and you bound over to the Superior Court, that's the piece that is missing, correct?
I would agree with that, Your Honor.
So although it's talking in terms of indictment, it's actually implicit in that is much more than indictment.
Well, the rule of indictment is it's handed out by a grand jury.
No, that's what I'm saying. So implicit, although it talks about indictment, the powerful protections that the defendant gets from an indictment is that it has to have gone before a grand jury.
That's correct.
Correct.
And in this case, that's what happened.
No, I understand that. So although the rule doesn't talk about grand jury, it's kind of code for all of those rights that you get by.
As Mr. Justice Spina pointed out, the rule doesn't talk about district attorney's complaints either.
Yeah.
And quite frankly, I was at a loss to find, either through my research or others, the words of district attorney's complaint in any case or rule. But nonetheless, we do know that where the defendant waives his right to be proceeded against by indictment in the Superior Court, that is recognized as a means by which the court will have jurisdiction with the consent of both the district attorney and, most importantly, the defendant. And we're not arguing otherwise, Your Honor. We're simply arguing, if I may, that the defendant in these circumstances has received all the substantive and procedural benefits that he was accorded by way of grand jury proceeding, indictment, opportunity to challenge indictment. Here, by contrast, if the defendant wished to go forward on these indictments, the originals, not the district attorney's complaints, but on the original indictments, and brought a motion for required finding at the close of the Commonwealth's case, jeopardy would have attached. He would have been found not guilty by reason of a faulty indictment, or unless the court agreed to let the Commonwealth amend the indictment to
that's Justice Courtney.
to conform with the evidence.
I take it, and again, Mr. Peterson, I just want to make sure, I take it that you're saying, I don't know about those other cases where it's not in writing. I don't know about those. Here I've got an indictment, I've had a grand jury, I've had an indictment, I've got a full colloquy, nobody contests the colloquy. Whatever the rule is protecting has been protected here, in this case, correct?
That would be the Commonwealth's position, Your Honor.
Yeah.
Unless,
So we don't have to worry about cases which were started with a complaint or, anything else.
I would concur, Your Honor. These are rather, I don't want to say hybrid, but they are not the circumstances contemplated by Rule 3 per se. But they are, in fact, we can certainly draw from Article 12 the substantive right to be indicted against. We can draw from de Goyer and Latte the fact that once a grand jury has convened and probable cause has been found, that the substantive rights have been fulfilled. It is simply the Commonwealth's position here the defendant has received the benefit of those rights, and when coupled with his willing, knowing, and voluntary waiver, which was, I would submit, in a colloquy far more extensive than the Rule 59 form, which was created perhaps in the Depression era and still cites to law that it has been overruled, I would say the court, not only the Superior Court, but the Supreme Judicial Court could say that beyond a reasonable doubt, the defendant knowingly and voluntarily waived his right to indictment. And unless the Court has further questions, I'll rest upon my brief.
Thank you, Mr. Peterson. We'll take a short break.
All right.